Okay, welcome again, friends, law students, lawyers, legal interns, juniors who are willing to learn the legal drafting course with me here online. So I've just prepared a checklist of 35 odd points which can help you when you're sitting on a draft and looking what needs to be covered. So I'll just quickly have a review of what I have prepared in this PDF. Though it is available on my website, you people can go and download it. But for your reference, which I'm going to teach in my course, I'm going to mention it here. What all needs to be covered when you're preparing a draft for your court case. One, it should be addressed to the right court. That's very important. That's the first and foremost thing to do. Then the party's name should be mentioned very clearly and correctly. Once it is filed, it is very difficult to amend it and put it again. So you are going to lose on time if you do that. Memo of parties with age and complete address should be mentioned. Then you need to state facts only, material facts, which are relevant to your case. Prayer clause must be there in every petition. In the end, what are you going to ask from the court? So you must know what should be the outcome of a case. Then affidavit in support. It can be short, it can be detailed, depending on the need of the court. Miscellaneous applications are to be separately filed. For condonation, let's say there is a delay beyond limitation period, it has to be moved. If you don't have a certified copy of the order, exemption need to be moved or asked in your petition. Signature at the bottom of your complaint petition should be there, which just comes before the verification. 10th, index. Very important. That's going to help you out how your case and annexures, everything will be done in order. Naming of annexures. Should I name it P1? Should I name it C1 or A2? It depends on the courts, and for your own convenience, how you remember it also makes sense. So for consumer courts, I do it like C1, C2, C3. For high courts, usually P1, P2, P3. And for tribunals, let's say CAT, AFT, A1, A2. So it is all your convenience. As such, there is no such rule. But yes, as per your convenience, you can do it. Then noting down facts in the right chronology and sequence. Day 1 to day last. It should not be mismatched. Like you're mentioning what should be mentioned at item number 5th at the last. It should be a proper sequence. Law proposition, law point. What is there in your case? Is it one of its own kind? Is something new coming up? So you must know what all possible outcomes can be there once you are presenting your case to the judge. Yes, you can quote judgments in your case. That will help even judge to assimilate what is the recent position of law on your case. You can quote the relevant part as well. You can just cut, copy, paste it. But do not make it a very bulky affair. Only the relevant paras should be mentioned. And only if the judgment is contextually correct in your case. Now, when you are putting up an annexation in the petition, it has to be attested by an advocate. We write a true copy for high courts. That has come from the high court. So this is also needs to be done. There cannot be any affidavit for minor. It has to be filed through guardian. A point to remember, especially in protection petitions, people forget that for a minor, it has to be through a guardian. Now, companies can always be sued through authorization of someone. It can be through authorized representative, managing director. You cannot just sue a company individually alone. It has to be through someone. Then vernacular calling mentions to the set of documents of same nature. Let's say you have a communication. Like you have 15-20 emails. You cannot put each and every communication as an annexure. Otherwise, it will be too lengthy for a judge to assimilate, like A1, A2, A25. It can be moved one set of documents as A1 only, calling. So that's the use of it. Now margin space, font space, I have already told in my previous video. It is as per the directions of the court. Usually it is 1.25 on top, 0.75 at bottom, and on right and left margin as well, 1.25. Then double space margin. Most common fonts used are Poundale and Times New Roman. So it can be noted from my website as well. And before typing your draft, you must make notes. That's a very important and useful insight. Then if the person is not available, he is abroad, there is no one to sign on his behalf, then through special power of attorney or general power of attorney, it can be filed through someone. So you must know, when a person is unavailable, he can still file the case. Tickets and stamps in Nakalatnama, it depends from court to court. Like RERA uses 10 rupees stamp, whereas High Court uses a welfare stamp of 25 rupees plus 3 rupees extra. So you can probably get in touch with your Munshi. He is the best person to comment upon this. Now, registry filing procedure, it is varying from all courts. So every court has its own set of procedures. The better and the best one is to go and just check it out, because it changes every month. For me, it is a discovery. So I always say, just go and check. Whenever you get a draft or a case assigned, just go and check the latest stance of the registry. As a young lawyer, as a legal intern, you must know how to operate a website, how to check orders from the website of courts. Then only you can search when you get a reference or when you get a law proposition. You should be able to quickly search judgments on the website of these courts. Additional evidence can also be brought up at what stage. So you need to master the knowledge of law also, that what can be the possibilities at different stages of a case. Grounds of appeal. On what grounds you can challenge an appeal. It is also an important thing. Subjective question of law, in case you are going for a second appeal, because already 2 courts have passed an order. Now you are agitating it before another court. So you need to find more reasons for justifying yourself to again fight for the same reason at third level. Legal notice representation, that's the best thing to do when your purpose doesn't get served. Before beginning with a legal fight, you must send a legal notice and representation. It's the most safest and best way to move forward with your legal battles. Then number of sets to be given. Let's say in High Court it goes 1 if a single judge is listening. For consumer courts it is always 3. For CAT tribunals or AFT it is 2. So depending on the number of people sitting on the dice, the sets can be given. Now stages and procedure. So you need to know what is going to come next in your case. So you should be far-sighted enough, and you should probably, before beginning up with your arguments or maybe filing up your case, you should know what are the possibilities of this case. And fee structure, there is no such MRP. There's no such coded thing here in law. You can code whatever people are willing and ready to give you. So it becomes with time that you're able to charge a good fee from your clients. That's why lawyers encash their reputation. Expected timeline, when the case can end or you can get a favorable order, you should be able to actually predict how long can a case run. Now appeal, what is the next step of action? If your case doesn't get decided in your own favor, then you need to know the next steps also. Then miscellaneous can be anything which is concerned with your petition. There can be a multiple petition in the petition, how you are going to put that in your draft. So hope I've covered some of the basics of legal draft and pleadings, which are going to be helpful in your own learnings when you're there in the courts. Again, if you have any questions, my number is there. If you're willing to enroll for the course, you can always give up a buzz and I'll be able to answer you. So again, thanks for watching and looking forward to serve you. Thank you.